Okay, good morning. The Hearing Board of the South Coast Air Quality Management District is in session. Today is Thursday, December 19th, 2019. The time is 9:05 a.m. and we are meeting in the Hearing Board room in Diamond Bar. We have two changes to our calendar for today. The cases of Train US Inc., case number 6150-2, and Carrier Corporation, case number 6156-1, for regular product variances are both off calendar for the same reason that the governing board amended Rule 1111, and they are no longer needing a variance. We have one matter that remains on the calendar for today, and then we'll have a hearing board training session later on. The matter on the calendar that remains is South Coast AQMD versus John Esposito Porsche, case number 6164-1, for an order for abatement. And who is representing the executive officer today?
Catherine Roberts for the executive officer.
Morning, Ms. Roberts. And I don't see anyone, but is anyone here to represent the respondent, John Esposito Porsche? Ms. Roberts, have you heard anything from
I have not, but as of last week, I heard from the facility and they were planning to attend this morning.
And did we hear you say before the hearing began that this is a stipulated order?
It is.
Okay, but we don't have anyone here to give their stipulation.
No, we did submit to the board, which we would ask to be Exhibit 1, a signed stipulation.
Okay, I didn't realize it was signed. Okay, well, let's mark that as Exhibit 1, and that is the proposed findings and decision of the hearing board, which, as Ms. Roberts noted, is signed by Lorena Esposito, the owner. And then what we'll do is I think we'll go off the record until 9:15 and give the respondent a little more time to appear. So we're off the record until 9:15. Okay, we're going to go back on the record. It is now after 9:15 a.m. and we still have not, I'm going to just call and see for any appearances for representatives of John Esposito Porsche. And I don't see anyone has come. And so we're going to proceed.
Madam Chair?
Yes.
If it's possible, we would like to request a continuance based on questions that the district does have for Ms. Esposito at this time regarding the current permit status of the equipment under consideration for order for abatement.
Can you tell us, meaning do you believe they might have a permit?
Well, the district has received, quite frankly, conflicting information. The facility has indicated to us that they have submitted a permit application that would start the process of getting them into compliance. We are unable to verify that at the district as of this morning. And given that there's nobody here from the facility to clarify that under oath, we would like a continuance on that basis.
Okay, that would, I'm looking at your exhibit number 1 and the tight time frame in which you have set forth. That would jeopardize your tight time frame.
It would require a change to the stipulation, almost certainly. But based on the information that the district currently have, that might be necessary.
Would it be possible to have the information by 9:30, or this is the only matter we have other than training? If we were to take a short recess to try to gather that information and possibly see if respondent does show, would that?
I'm willing to wait. I have attempted to call the respondent. I have not heard from them.
And of course, that's not your burden to do, but I just was wondering if, rather than that, if there's a way to check with district staff to find out if the proper fees were paid and the application was.
At this point, the district would proceed on the assumption that they have not been. That's the information that the district was able to determine as of this morning. The respondent has informally told me differently, and I'm certainly willing to hear any explanation, but I don't have any information that a permit has been submitted at this time that the district can confirm.
And you can't, there's no one you can check with that would just be able to look in the records and say, yes, in fact, an application was submitted, and yes, in fact, the correct fees were paid.
So permitting services right now, because they're undergoing a move, does have a bit of a backlog, and so informed me that it is possible that they could have received it and there's not data entry that has confirmed that. But as we have confirmed this morning that we have looked, we have not received from the district a permit with application with proper fees.
Well, let me ask you this as well. I would put it to a vote of the board for continuance, but my question is, could we change the order and make it contingent upon should there not be a permit by such and such a date submitted?
Well, frankly, the stipulation was ordered, and as stipulated to, the respondent would have until December 31st to finally submit that permit. But based on the conduct that the district has observed, it's likely that might not be adhered to. And that would maybe necessitate further action by the district to enforce it, even if this board were to enter the stipulation today.
Okay, well then, it seems to me, and I would put it to a vote, it seems to me we should move forward. And the order would stand should this board grant it. And especially given what you're saying about concerns about compliance and not knowing whether that application was submitted, I think this board would rest easier knowing that there was a requirement to do so by a certain date.
We are prepared to proceed if that's what the board prefers.
I will put it to my other board members. Mr. Balagopalan.
Yeah, I think even though the application is not data entered, they have a file where they keep all because every application there's a receipt is timestamped and put in a folder, and they do the data entry later. I don't know if anybody checked and see if there's any application there,
And my understanding is there is other parts to this there's other parts to this proposed order, which includes decommissioning or taking out of service
Yes.
a burner. So regardless of whether there's a permit, there's still, it appears that we haven't heard the matter, but it
Yes.
appears there are other issues. Is that correct?
That is correct, yes. And my witness today is telling me that Mr. Balagopalan, and there is not in that file, as of this morning, any information that a permit application has been submitted.
Right, and then if it's not there, then it implies they didn't submit it then.
That's correct.
Okay. Ms. Verdugo Peralta?
Just a question, there's been no notice of violation up to this point. Has there been any?
There are, and we will get into the merits of that, but I think that the question more for us right now is, should we continue this or should we just move forward with it? Dr. Bernstein?
Seems to me that we're here, let's move forward.
I agree. Unless anyone else wishes to entertain a continuance, I think the board will not entertain that continuance, and understanding that you were attempting to get all the information before moving forward. Okay. Oh, Senator.
What is the pleasure of the district in this regard?
Again, our request would have been for continuance just for on the sole basis to ensure that the board has all of the relevant information, which right now does require some testimony from the respondent who is not present.
Given the fact they're not here, then what's the effect of the decision that we make?
As I mentioned to the chair, the district is prepared to go forward if that is the decision of the board. We are prepared to, we will have testimony this morning that is sufficient for this board to find good cause and to issue the stipulation as we have submitted. But again, just out of an abundance of deference, to ask the respondent to be able to testify under oath as to the current status.
Let me ask you two questions. Number one, proposed, and we've marked it as Exhibit 1, proposed condition number 2 on page 3 just simply states respondent shall submit an application by December 31st. So if that's done, they would just be in compliance with that condition. Is that correct?
That's correct.
Okay, so there's, in order to grant an order for abatement with that condition, we don't necessarily need to have the information as to whether they've done it already or will do it by December 31st.
Well, respectfully, Madam Chair, based on some of the testimony you will hear, there are some questions as to the specific specifications as to the permit. There was a prior permit application, but as the testimony will demonstrate, there were some concerns that the equipment, specifically a burner attached to that, was not accurate as to what was actually on site at the facility, and the facility had some challenge in being able to submit a correct application with the correct equipment that the district would accept.
So without, if it is true that an application was submitted, would that then take away any other violations or possible causes of action?
It would bring them into immediate partial compliance, which is the most concern for the district. It is only the booth that's currently operating that does emit air contaminants. As of right now, the burner attached to it is non-compliant, but it is not being operated. The district does require for full compliance that it be rendered permanently inoperable or removed, but it's not at issue imminently because it is not being used based on the evidence that the district has. The booth, however, is being used and is in current non-compliance until a permit is submitted.
Senator.
Condition number 5 pretty much concludes everything that they shall do and shall have done, because it's notified the clerk. And we can take the position that if they notify the clerk that they're in compliance with the conditions.
Senator, what's being requested is that we continue this hearing, so we would not, this order would not be an active granted order. It would be, we would not be hearing this matter today. So none of these conditions would take effect. We would not have the hearing today. There would be no order.
Let's continue, let's do that and move on.
So are you of the position we should have the hearing?
I would think we have to, if you can have a hearing then, and have them stipulate at a later date that they're in compliance with all the conditions, and notify the clerk that that's the case,
So it sounds to me like you would like to move forward
then
as
then
well.
it's done.
Okay, let's do that. And we appreciate your position. So I'm going to begin by asking anyone who wishes to testify today to please rise to be sworn in. Please raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God? I do. Thank you. Okay, first, before we start with your opening, Ms. Roberts, I wanted to refer to Hearing Board Rule 8B2, since the responding party is not present. And that reads that if the responding party fails to attend the hearing, the petitioning party has provided the hearing board with proof of service on the respondent of the petition. The hearing board may rule on the petition in the respondent's absence. So before we continue, I guess the second step today will be for us to have proof of service, and then we can move on with the hearing.
I believe that proof of service was submitted to the board, but I have a
Okay.
copy of it if the board does not currently have a copy.
Should we take a moment, or we can just pass it around? It's part of the file, so we can just pass it around. And then while we're doing that, if you'd like to give your opening.
Of course. Thank you. As the board has heard a little bit about this, I would like to back up a bit. The district brought this petition for an order for abatement following the issuance of a second notice of violation to the facility that confirmed that the respondent facility is continuing to use a paint spray booth at their facility without a permit to operate in violation of District Rule 203. The evidence this morning from the district will show that the district has been investigating this facility since March of 2018. At that time, the district confirmed the presence of the spray booth on site at the facility and confirmed that the district had an application for a permit, but that application was expired for non-payment. Further follow-up inspections following a notice to comply that was formally issued to the respondent facility to inform them of all of the efforts they needed to take in order to come into compliance did not work. Further inspection verified that the paint spray booth was being operated by the respondent facility, and the first notice of violation was issued following this inspection in October of 2018. The district conducted additional investigations at the request of engineering at the district to determine that the burner that is attached to this paint spray booth does not match the application that was expired that the district did have on file. And although that burner was not observed in operation, it remained on site at the facility without any application or permit and is considered non-compliant with district rules. Further follow-up inspections, most recently in August of 2019, has confirmed that the facility continues to regularly operate the paint spray booth, although not with the burner. The facility was issued a second notice of violation following that August 2019 inspection, necessitating this petition. As the board has marked as exhibit number 1, we do have a stipulated proposed order. That proposed order lays out 4 principal steps that we would ask the board to order. First, the order would require that the burner not be operated. It is a non-compliant burner and there is no application or permit on file for that. Second, it does require the facility to immediately seek a permit for the paint spray booth, but not the burner. Third, it does require that the non-compliant burner be rendered permanently inoperable. And last, it requires that if the facility is deciding to get a different burner, as it has indicated to staff it intends to do, it must submit an application and ultimately get a permit to install and operate that new burner. The district's understanding is that as of today, only that first step is in process, that as the district understands, The burner is not in operation, but no other steps have been taken. But we believe that the stipulated proposed order is a path to get this facility into compliance. And based on the evidence that we believe will be presented today, there is good cause to issue this order. Thank you.
Thank you. One thing before we move forward. First of all, I just wanted to note for the record, I just was thinking of this after the request for continuance was denied. It's not a good precedent for respondents simply not to show for a noticed hearing, and when there are questions that they need to answer, can't be answered, and we just continue it until they feel like showing up. So while I appreciate your good faith in asking for that, Ms. Roberts, I think it was the right decision to move forward. The other thing I wanted to note, and then get agreement or not agreement from the rest of the board, is we have received a proof of service. That proof of service was filed along with the petition itself for order for abatement, and it shows that on November 21st of this year, Lorena Esposito, identified as the owner of the respondent's facility, was served by personal service with the petition by Guyan Cavoto. I hope I'm saying that name correctly. And so given the rule, our Rule 8B2, we may rule on the petition in respondent's absence, but I want to make sure that all board members, I believe that we may continue with the hearing and rule in their absence. But I'm going to take everyone in turn and make sure we all agree. Senator, do you agree that we may continue with the respondents, without the respondent, in the absence of the respondent, to both hear this matter and rule, given that they have been personally served?
The concern I have is that the stipulated order, we don't know that they in fact are stipulated anything here.
Well, that way, no, okay. Well, that we can take up as we hear the merits. The question, though, is whether we want to even hear the merits and rule in their absence.
They made a lot of mistakes along the way. I'd rather have them here if you want to know what the truth, how I feel about it.
You want them here?
I want them here to answer the question. They were cited, and they still violated the terms and conditions.
We're going to hear evidence of that, but okay, you want them here. Dr. Bernstein, do you agree we can continue in absence of the respondent, given that they have been properly served?
Yes, ma'am, we should continue.
Mr. Balagopalan?
Yes, I think we should.
And Ms. Verdugo Peralta?
Yes, I would like to continue, and this may be a irrelevant question, but are there any penalties that we ever impose on companies when they don't appear after there's been such an effort to try to bring them into compliance?
The penalty is a clear one. The penalty is they're not here to answer. And so because they have chosen not to appear, they're at a disadvantage. And that's why we make the determination whether we want to move in their absence. So a lot of times, in other matters, we will ask respondent about their financial situation, for example, and take that into account in setting dates by which they have to comply, those kinds of things. And if they don't come to explain their circumstances, or as Ms. Roberts noted, perhaps there's more information. Perhaps they did, in fact, file a permit application, but we don't know because they didn't show today. So it is a disadvantage. So no, there's no penalties other than that.
I agree to go forward this.
Okay, so on a vote of 4-1, we're going to move forward and both hear the matter and rule in the absence of respondent. And Ms. Roberts, you may present your first witness.
Should I step out of the room?
Thank you. The district calls Jason Luong. Good morning. Could you state and spell your name for the record, please?
Jason Leong, Jasonleong.
And did you take the oath this morning?
I did.
Thank you. What is your position with the district?
I'm an Air Quality Inspector 2.
And how long have you been in that position?
I've worked as an air quality inspector for a little more than 4.5 years.
And are you familiar with the respondent facility?
I am.
And is that facility within the district's jurisdiction?
Yes, it is.
And is that facility within your responsible area for inspection?
Yes, it is.
And did you inspect that facility in March of 2018?
I did.
And what were the findings from that inspection?
I observed a paint spray booth installed but not operating on that day. It had attached to it a heater/burner, though that was not connected to any gas lines.
And did you investigate as to whether or not that spray booth was permitted with the district?
Prior to my inspection, I looked in our database and saw that a permit application had been submitted in December of 2016. However, a few months after that, it expired due to non-payment of fees. I think that expiration took place April of 2017.
And did you discuss the findings of your investigation with anyone at the facility?
I did. I discussed this with Ms. Esposito, the owner. I explained to her that if the facility wishes to operate the booth moving forward, that in order to comply with district rules, it would need to pay the delinquent fees to reactivate the current application on file.
And following that inspection, did the district issue a notice to comply to the facility?
Not immediately, although I did so a couple months later in May when I saw that the facility still had not yet paid off the delinquent fees to reactivate the application on file.
And what did the notice to comply require?
The notice to comply required the facility to comply with Rule 203, which says that the facility needs to apply and obtain a permit to operate prior to using the paint spray booth.
And at the time that you did that 2018 inspection in March, was the district aware of any difference between the burner that you observed on site and the burner that was included in the then expired permit application?
At that time, I was not aware of any difference between the burner on site and the burner in the application.
And did anyone at the district discuss this facility and request your follow-up?
I did conduct a follow-up in August to follow up on the notice to comply.
And what was the results of that follow-up?
So I returned to the facility in August of 2018 and observed the paint spray booth in operation.
And how did you confirm that the booth was operating at that time?
The lights were on in the booth. There were auto body parts recently spray painted that were drying within the booth, and the booth doors were closed.
Did you observe the burner attached to the booth in operation at that time?
The burners were not in operation at that time.
And following that, noticing that it was in operation in August, you did not immediately issue a notice of violation, is that correct?
Correct.
But you did issue a notice of violation in October of 2018.
I did.
And what was the reason that you waited until October?
During my inspection visit in August, Ms. Esposito stated that she wished to comply and would send a check out immediately to pay off the delinquent fees and bring that permit application back into active status.
And following that notice of violation, or that inspection, did you discuss the facility again with anyone else at the district?
I did. I was in contact with our engineer, Hamang Desai. He was taking a look at the permit application and asked me to return to the facility if I could and confirm whether the burner attached to the paint spray booth actually matched the burner in the permit application.
And did you conduct that requested inspection follow-up?
I did. I did head back out to the facility in October.
And what did you find based on that follow-up?
I took photos of the gas train assembly as requested by our engineer and brought those photos back for him to review.
Okay. Following the first notice of violation in 2018, did you ever conduct a follow-up inspection in 2019?
I did in August of 2019.
And what were your observations in the August of 2019 inspection?
So during my inspection visit in August of 2019, the paint spray booth was not in operation on that day of, but I did observe the same paint spray booth on site along with the same burner assembly.
Did you observe anything else at the facility that would indicate operation of the booth?
I did. On that day, there were auto body parts recently spray painted that were sitting outside of the spray booth to dry. I also reviewed VOC records maintained by the facility that day.
And did those records indicate that the booth had been operated?
Yes, so the VOC records showed that the facility mixed paint several times per month. These records dated back several months, in fact, more than a year or two.
And what was the action the district took following that August 2019 inspection?
So I served a second notice of violation in response to my, as a result of my observations.
And at that August of 2019 inspection, did you observe the burners in operation at that time?
The burners were not in operation at that time.
Did you discuss either the violation or the paint spray booth more generally with the facility at that time?
I did. I shared with them that based on their VOC records and based on the statements of their painter who was on site, that that was sufficient evidence that they were that they remained in violation of Rule 203A, that they were continuing to operate the paint spray booth. And I shared with them how they could come back into compliance.
At that point, what steps did the district indicate they would need to take to come back into compliance?
At that point, I explained to them that they would need to submit a permit application because the existing expired permit application on file didn't match the equipment that was on site completely.
Okay. And to your knowledge, is the facility still operating that paint spray booth, or have you received any information that suggests they're not operating it?
I have not received any information that suggests they are not operating the booth.
Thank you. I have no further questions.
Thank you. Mr. Balagopalan?
All right. Mr. Lau, was a permit to construct issued?
Yes,
And you have a copy of that?
I don't, but I believe our engineer may.
And can you look at that and see if, did it address the burner in the description of the spray booth?
Yes, it does it does specify a burner.
Burner, okay. And did you match, so is that did you have with you at that time during inspection a copy of that permit to construct?
I did not.
You did not, okay. So subsequently, I mean, you say it didn't match, what did you use to compare what was issued and what was on site?
So as I mentioned earlier, I was in conversation with our engineer, and he provided me with photos as to what to expect to see. And when I made that subsequent inspection visit in October of 2018, what I saw on site it didn't match what I was expecting to see based on my conversation with our engineer.
When you say it didn't match, is it the physical description? I mean, the description that was on the permit with what they had on there, or was it from photographs or whatever you had?
So I took a look at the unit on site, specifically the gas train assembly, and it didn't look anything like the images of the gas train assembly that our engineer said I should expect to see based on their application.
I'm a little confused. Did the permit to construct describe the burner?
Yes,
And did it give a rating and a make and model?
yes.
Did you match those description with what they had? Or did you just look at the pictures or whatever drawing you had?
I just looked at the pictures. There were no specification plates that I was able to see on the unit when I was there.
And the burner was included in the spray booth permit, correct?
Yes,
And then you mentioned that when you were there, the first time you were there, they were not operating, but subsequently, when you were there the second time, they were operating and the permit had expired. And that was due to non-payment of fees, is that what you said?
yes.
And did you let them know that it was due to why the permit had expired?
Yes, I explained to them that they owed fees, and I communicated to them the specific amounts of these fees.
To your knowledge, do you know if they received the invoice from the district about the fees?
To my knowledge, I'm not sure that they received the invoices, although I provided them with that information.
Did you give them a
Subsequently.
copy? What did you provide, a copy of the invoice?
I
or you just-
provided them with invoice numbers and the dollar amounts.
And did you give them some information who to call here to find, or how to pay the fees?
Yes, I did.
What did you provide?
I provided them with telephone numbers that they can call to arrange the payment of the fees. I showed them our district website and how they can navigate that to pay the fees that way as well.
Okay, and they indicated to you that they would do that,
Yes,
and turned out they still haven't done that yet?
they haven't done that to my knowledge.
And so that was a prorated fee, right? When, do you happen to know, I think the petition said the permit to construct was issued, let's see, on January 19, 2017. Do you know on the application when they, in the 400A form, do you have that in front of you?
Yes.
Did they indicate when they will have the construction completed and they would start operation, the date?
So it looks like they have the estimated start date of construction to be December 26, 2016, and then the estimated end date of construction to be, it's a little hard to read, but it may be January 6, 2017.
January 6, okay. In the ordered petition, the stipulated order, there I see a requirement for a separate application for the burner. Do you happen to know why a separate application needed when the initial was issued on the same permit as the spray booth?
So what we know now is that the burner on site doesn't match the application on file. The facility indicated that they may wish to come into compliance right away by permitting the spray booth alone and then addressing the burner later when it's ready to start using that.
So, I can ask this of the engineer, do they modify their permit or do they have to submit a whole new application for that permit?
I'm not sure.
Okay, that
I am planning to call
Oh, call
the
the engineer.
engineer following.
okay. And do you know if there's a rule applicable to the burner?
1147,
Okay,
Rule 1147.
all right, thank you.
Can a spray booth operate without a burner?
It can.
Well, it can. Okay, so the fact that the spray booth has been operating doesn't necessarily mean they've been operating the burner?
Correct.
Okay. Did you meet with Miss Esposito each time you were at the facility?
She was there for most of my inspection visits.
And did she identify herself as the owner?
Yes.
Okay. And, those are my questions. Anyone else have questions? Ms. Verdugo-Peralta?
Thank you, Madam Chair. When you spoke to Ms. Esposito, did she seem willing to want to come into compliance and pay the fees?
Each time I spoke with her, she stated her intention of paying the fees as soon as possible.
And what is the amount to this point that they owe?
I believe our engineer can actually speak to that.
Okay, I'll wait for that. Thank you.
Anyone else have any questions for Mr. Leong, Senator?
Do you have the confidence level that Ms. Esposito was familiar with what we do here at AQMD?
Yes.
Well, then, you know, the first notice of violation was written, although other things had occurred before it was written, on August 17th, 2018. It was not served until about 2 months later. So, served to her. How do we know it was served to her?
How do I know it was served to her? I sent it via certified mail and I received the signed receipt.
You have a copy of all that?
Yes.
Okay. 2 months later it could suggest to her, well, maybe they're not that serious, I just keep operating. The next investigation for notice of violation was August 20th, 2018. It was not served until the September 3rd, 2019. That's a year later.
No, after serving that first notice of violation in 2018, my next follow-up inspection was in August of 2019.
Then we have here August 2018.
Perhaps you can explain to the senator what that means, why there are two different dates, one at the bottom and one at the top.
I know what that is. When they could inspect it was 2000, and find the violation was the first one at the top.
If I may, there are two different inspections. One was in August of 2018 that led to a notice of violation
The notice of violation, yes.
in October of 2018. But the inspector also conducted a second inspection in August of 2019, and that led to a notice of violation in September of 2019.
So this notice of violation number 69655 was found to be out of compliance August 20th, 2018. Is that correct?
Yes.
And it was served on the respondent September 3rd, 2019. Is that correct?
Correct.
All right, so
If I may ask a couple of follow-up questions.
I'll allow that because we need to explain what that means.
So, Mr. Leong, when you conducted the August of 2019 inspection and you determined there were ongoing violations, how did you set the date of violation?
So I reviewed the VOC records, which showed that the facility mixed paints going back, as I said, many, many, many months. So I determined the violation date on this second notice to be August 20th, 2018, because that was the first instance of a violation subsequent to the date on the first notice of violation.
But that August of 2019 inspection, Was that the only date of violation that you noticed from the VOC records was August 20th of 2018, or did you notice additional dates?
I noticed additional dates.
But you only issued a single notice of violation to capture all of the violations, is that correct?
Yes,
And you simply dated that to the earliest date of violation after the first violation, is that correct?
yes,
And the first violation was August 17th.
yes.
It is right here.
2018.
Yeah, it's very confusing to me. Therefore, it would be confusing to the respondent, in my view.
What was it explained to the respondent?
I explained to the respondent how I determined the violation date.
Which is all inclusive, all the violations prior thereto and up to that point.
Yes,
Did you list them at any time?
I did not.
Well,
Any other questions for Mr. Leon? Okay. Did you have additional questions?
No, I do have an additional witness.
Okay, and we'll take that witness. As we're going through this, I just want to, I wanted to understand, how did we receive the signed stipulation from Ms. Esposito? How was it received and who received it?
So district council has worked with the respondent facility on this stipulation. I personally received it from the facility, and our office did submit it to the board
Okay.
once it was signed.
Okay, and so it's your representation, not your testimony, but your representation that you were actually speaking with and negotiating this stipulated order with Ms. Esposito, standing in as the representative of the respondent.
That is my representation, although I would ask that as the board deliberates, we believe that there is evidence sufficient to make the findings, even if this were not a stipulated order,
Yeah.
that there is currently a violation, and that there is still good cause to make the findings requisite, even if this were not. But yes, that is my representation.
And that is what I would like to do, but we haven't heard all the evidence yet or deliberated. So I want to make sure that at least is squared away. Senator?
my question again to you, sir. How many years have you worked for the district?
A little more than 4.5.
4.5 years. And you went through a training program to be able to do this, is that correct?
Yes.
Did any time during the training program that they suggested to you that you could list a cluster violation notice before you sign it, before you issue it? Violation?
If I'm understanding your question
A
correctly,
number of violations at the site, which is some kind could be considered to be like a cluster, not of them. And then before you write the notice of violation, and before you serve it.
I issued the second violation based on the best way I knew how.
Let me ask you, because we've seen many of these before, okay? Is it, let's just clarify, what goes in the box on the upper right-hand side of a notice of violation? Is that your date of inspection?
It's not.
Okay. Is it the date by which, given evidence that you have gathered from the site of the first violation?
Yes.
Okay. Is that the usual way in which notices of violations are, whatever the word is, are issued when there are continuing violations or multiple violations?
Yes.
Okay. Do you have other questions?
I would expect in your descriptions of violation that you would insert at that point in time the number of times you visited this facility and that you noticed that they're in violation. Then maybe the last one you put up at the date, but you didn't describe anything that you did prior there to this date, prior to and including up to this date. When you write a prescription, the description, it should, if you intend for it to represent the number of times you've been there and notice of violation, non-compliance, when you put it in
Is that a question?
when you put it, included it in this description? So that at least we will know what you're talking about.
The question, I believe, is it usual practice in the description portion of a notice of violation to explain the different violations in terms of dates or numbers, I believe?
My understanding is the usual practice is to state the rule that's been violated in this section of the form.
State the rules at any time, all times, how many times that you visited the facility. What are you talking? State the rule, you've done that, indicating that one time you were there and you noticed a violation. But you're saying to me, there's been a lot of times you were there, you noticed a violation, but you did not say when you were there.
I don't believe that's what Mr. Leong said. Mr. Leong, just to restate, is it your testimony that you went on August, I believe it's 19th of 2019, and that was your inspection after August of 2018, correct?
Correct.
Okay, so it's not that you inspected multiple times after August 2018, that was your first inspection after?
That was my first
There was the October, correct? I'm sorry. You inspected in August 2018, October 2018, and August 2019, correct? Okay. In August 2019, can you just please repeat? I know you don't have to repeat. Let me summarize what I believe you said. You noted that the spray booth was in operation without a permit. Is that correct?
Based on a review of the VOC records and based on the conversation with the painter.
Okay. And so in August 2019, when you were there inspecting, you looked at the VOC records, correct?
Correct.
And the VOC records told you in August 2019 that this spray booth without a permit had been operated since August of 2018, correct?
Correct.
Okay, and that is why in September of 2019 you issued an NOV, which then stated as the date of violation that early 2018 date.
Correct.
Okay. Are there any other questions? Senator, do you have any other questions? Okay. Ms. Roberts, your next witness.
Thank you. The district would call Hamang Desai. Mr. Desai, can you state and spell your name for the record, please?
Hemang, Hemang, last name Desai, Des, as in Sam, AI.
And did you take the oath this morning?
I did.
And what's your position with the district?
I'm an air quality engineer too.
And are you familiar with the respondent facility?
Yes, I am.
And did you ever discuss this facility with the inspectors at the district?
I did.
Can you describe those discussions?
Can I go a little bit back? When we issued a permit to construct to the facility back in January of 2017, on August 15th of 2018, I wrote to Jason, who was the inspector for that sector, to inspect the facility to make sure that the equipment is installed as per specifications.
And so that led to the August inspection, is that correct?
That's correct.
And following that August inspection, did you ever ask Jason to go back to the facility?
No, I did not.
You didn't, did you ask him to verify the burner that was on site?
I did when on my original inspection, original request on August 15th.
Okay. And did Mr. Leong provide you with photos of the burner that was on site?
Yes, he did.
And did you review those photos?
I did.
And were they consistent with the permit application?
No.
Can you briefly describe what was the discrepancy between what the photos showed and what the application showed?
The photos of the burner that he sent me did not match the traditional the burner gas train assembly that was approved on the permit to construct.
Okay. To your knowledge, is it possible to continue operation of the spray booth without a burner?
Yes.
Okay. And to your knowledge, did the facility ever submit a permit application that was either corrected to the burner that did exist or was without a burner?
No.
So there's no application presently for just the spray booth?
Right.
And there is no application for the spray booth with the correct burner?
No.
And how recently have you confirmed with permitting services that that's the status
As of this morning.
as of this morning? That's all of my questions. Thank you.
Thank you. Anyone have, Mr. Balagopalan?
Mr. Desai, you gave a permit to construct. What was the reason for a permit to construct? Was this not a permit to construct / operate, or was it just a permit to construct?
I believe at the time we have a certification program for the burners that the district certifies. At that time, I believe we were in the process of recertifying those burners at the manufacturer level. So at the time, the policy was to issue permits to construct. Once recertifying letter was issued, then we would convert that to permit to operate, the permits to construct.
So when you issued the permit to construct for the burner, it was understanding that they would be recertified? Or that
Yes.
there was an existing certification, but it'll be recertified?
Yeah, it had expired around that time, so
Okay, and it was certified meeting 1147, so there was no condition on the permit to retest it, just requiring the certificate
right, it was just a matter of going through the process at the manufacturer level.
for the, so when you had the description of the burner, can you read the description of the burner, how you described it?
I read the whole description of the spray booth.
Not the spray, but you can just go to the part which has the burners.
The burner described as rated at 1 million BTU per hour, a Midco, that's the manufacturer. The model number is LNB 1000, and it's a low NOx burner.
So when you had the inspector go check, did you have him verify it was the same model, same rating, same model number? Or you gave him pictures of what it looked like, a similar model? How did you provide, what did you provide the inspector?
I sent him the pictures of how a typical, the Midco burner gas train assembly looks like. We have, when we certified at the manufacturer level, we have pictures of it. And so I provided Jason with that.
But did you provide the make, model number, and the rating?
I provided him the copy of the permit.
Did he compare? And from what we heard from Mr. Long, he didn't look at it didn't appear he verified those things.
I believe he did. He sent me the picture. He sent me the pictures of the assembly of the burners, and it did not match what we wrote on the permit or the Midco gas train assembly.
When you say it didn't match, the model number didn't match, the rating didn't match. Well, how do you know it didn't match?
The model gas train assembly, the pictures that we have for the certified burner, that did not match what they had at the shop.
So you don't know what they what burners was installed in?
No. From my understanding, I showed the pictures to my colleagues who are much more expert than me, and they said that this is definitely not the same burner, and it's the old used burner that the company bought.
And that was probably not certified?
No.
Okay. And so, and the reason for not, in the order it says do not operate the burner unless they put in a compliant burner? Is that what is going to be then, the requirement?
Yes.
So once they submit a compliant burner, then they can, or information on the compliant burner, then they can install or modify their permit to have that included?
They will have to restart the whole process again for reapplying the permit because the original permit to construct have expired.
Right, I think they are going, the order required them to submit an application for a permit to operate for the existing burner, correct? Because then they'll have a temporary permit to operate once they submit the application.
I believe if they submit the application, they would not be operating the burner, so it
No,
would be.
without the burner.
Correct,
And then-
without.
And then subsequently, if they do choose to operate the burner and they get a compliant burner, they'll resubmit for modification of the permit.
Yes, they will have to resubmit.
Okay, all right, thank you.
I might have needed to ask Mr. Leong, but perhaps you know. Do you know what rule requires the burner to be removed from the premises if it's not permitted? Or they continue to be in violation, or is, I understood that was part of the rule, or,
Well, either they comply with the Rule 1147, the burner, to meet the requirements of the rule, or they don't operate, or we would deny their permit.
are they in violation? Well, and again, this might be a question for Mr. Leong, but if you know, if they continue to have a non-compliant, non-permitted burner sitting on the premises, but they're not operating it, is that a violation?
Not really, but they have to do a permanently disable the burner, that they don't have a temptation to hook it up.
Okay, and that is clear in the rule, or,
No, the rule does not say specifically that.
okay. Thank you, I just wanted to be clear on that. Ms. Verdugo Peralta, and then, I'm sorry, did I interrupt you? You were done, okay.
Oh, thank you, Madam Chair. So again, what is the total amount to this point that they owe?
I looked our finance database, and right now they have an outstanding balance of $2,480.93.
Okay, and this is inclusive of all fees, notices of violation, everything to this point, but not possibly including future fees, is that correct?
Does not include the notice of violation fees. This is after the permit was issued.
Okay.
The original permit was issued, and they have to pay annual operating fees every year. And this is based on that, plus the penalties, and I believe some AB 2588 fees. But this does not include the notice of violation fees. or
Okay, so what I'm
fines.
trying to get to, though, I'm trying to get to what's the total amount to this point that they owe all fees, everything? Do we know?
Including the new permits that they have to apply for?
Not including the new permits, just up to this point, what did they need to pay to go forward?
I believe that's the amount that I gave you, $2,480.93.
If I could, Ms. Vertigo Peralta, the district council does have in process a proposed settlement, but hasn't finalized any settlement for penalties. But that is completely separate from any fees that they would pay.
Right, that is separate, and we don't normally, or we don't ask regarding those fees or settlement penalties. But I think it is relevant to know what they need to pay in order to come into compliance.
I'm trying to understand their side of it as to why they're not complying, why they're not paying this amount. 2,480 doesn't seem like it's a huge amount. So, that's what I was trying to find out. What is the reason that they're not coming into compliance, why they're not responding? Really, they're really not responding to the district. They're just ignoring the district and what the inspector has gone out and found, and that they are in violation. To me, they're not taking it that seriously, especially if we're talking about $2,400.
You can ask Mr. Leong if you'd like, if in his many visits to the facility and conversations with Ms. Esposito and others at the facility, whether there was any reason that was given to him as to noncompliance, but otherwise we have no, it's hearsay, but we can take hearsay.
So I would like to ask that question of Mr. Leok.
The facility didn't provide any reason as to why they're not in compliance. Each time I spoke with them, Ms. Esposito indicated a desire to submit the delinquent fees as soon as possible.
Okay, and my other questions go to the actual notices of violation. I can see where the senator is coming from in reference to the dates. It is confusing, especially on the notice of violation 69655, the date of 8/2018, and then over a year later that it's 9/3/2019. It doesn't appear that there was any action going on in between that time from the district. So to me, it would be helpful to know between those two dates, what did occur? Were there more inspections, which it sounds like there were, but yet we don't really see them on the notice of
I think the
violation.
evidence has been so far that there were none. There were four inspections, one with a notice to comply, then the August 2018, then October 2018 with regard to the burner and determining whether it matched, and then not again until August 2019. The reason why the predating occurred is because in August 2019, so
Yeah.
so
It's
it's
not
been
that I-
asked and answered. If you have other questions.
It's not that I don't understand that, it's that to me, and I think to the senator, it would make sense to put those dates on the notice of violation so we can see that there was action in there in between the two dates. It's a clearer representation, I guess, of your visits out there, so that we understand that as well. It's not that I don't understand.
Again, there were
having
no
seen it.
visits, I think is the testimony. There were no other visits. It was based on records provided in August 2019. But if there's other questions, please.
Well, okay, so if there are records between the time of 2018 and 2019, and that's where this is coming from, then, I think it needs to be documented. It needs to be documented
Okay,
someplace.
is there a question? Because we'll talk about that in deliberation, but are there questions?
Was there a reason you didn't put that on there?
No. I included details in my report. I completed this form that you have before you in the way I typically do.
And again, I just want to be clear, to your knowledge, is that how inspectors typically represent a continuing violation on a notice of violation?
To my knowledge, yes.
Another question?
No other question?
I got a question.
Senator has a question. We were with Mr. Desai, but I assume you are continuing now with Mr. Leong, or did you want to go back to Mr.
If you
Desai?
if there were a continued violation, it would be incumbent upon you or the district to notify the respondent in writing or some form that they were continuously in violation. And the only way you do it is by the notice of violation. And that was not done, number one, notwithstanding what anybody's saying. That was not done. Now, when you look at the petition, you look at page,
Okay. I have to stop. I feel that we are all deliberating. Can we please ask questions? If you have questions, we will gather the evidence in this portion of the hearing, and we will discuss it during deliberation.
Madam Chair, if I may ask a couple of follow-up questions to Mr. Leong that I think might clear up some of this.
It certainly would be, why don't we do that, and then Senator, if you have additional questions, please ask those after.
Thank you. Mr. Leung, did you discuss with anyone at the facility the potential violations you observed in August of 2019?
Yes, during that August 2019 inspection visit, I met with the painter Gus Flores, along with Miss Esposito. And as I reviewed the VOC records that day, I shared with Miss Esposito my observation that the facility had repeatedly violated Rule 203A by operating the booth on multiple occasions in the preceding year.
Do you recall if Ms. Esposito was confused or unaware of the continuing nature of the violation?
No, she was in agreement with my observations and acknowledged that her facility continued to operate in violation repeatedly in the preceding year.
And based on your inspection of August 30th, by the time you left the facility, was the facility aware that they were going to receive an additional notice of violation?
Yes, they were.
Thank you.
Let me just ask you one other question, or one other series of questions. On August 19th, 2019, you observed drying parts right outside the spray booth, is that correct?
Yes,
Okay, so your observation was the spray booth was used on August 19th, 2019, is that correct?
yes, that's correct. And I discussed with the painter, Gus Flores, and he confirmed that any parts that are drying were recently sprayed and that all the spraying takes place in the paint spray booth.
Okay, and as of August 19th, 2019, and in fact, as of this morning, there is no permit to operate that spray booth, is that correct?
That is correct.
Okay, thank you.
In the petition, on, I guess it's page 2, line 26, clearly states that on August 30th, 2019, you conducted an inspection at the facility and determined the spray booth had been repeatedly operated since the prior notice of violation, which began August 20th, 2018.
Okay, and Mr. Leong just
I
testified that
know,
in fact
am I
that
going
is
to finish
correct.
before?
Well, are you asking a question? Because we're going over the
I'm
same
making
ground.
a statement, making a foundation for the purpose of asking a question. Doesn't that make sense?
I don't know, I haven't heard the question.
Then you have to wait until I'm finished. All right. And the trade proof of supervisor permit. Then my question then, therefore, wouldn't you think if it may be necessary, since the respondent's not here, and it's been stated that this was explained to the respondent, I'll ask the question, at the site on August 30th, 2019, they can say yes or no, what you said to them is true. Yes or no, do we understand what you telling us? And you said they did. And I would have asked them they didn't. But in any case, when you think it'd be appropriate, therefore, to list this in the notice of violation, that these events had occurred and what your findings were at that particular time, so that they would be officially notified. This is official notification.
I want to stop us here because Mr. Balagopalan just reminded me. But no respondent is here to appeal the notice of violation, and no respondent could appear to appeal a notice of violation. We do not consider whether notices of violations are proper. We don't consider whether notice of violations were properly issued. We're here to gather evidence as to whether, as of today, there is a violation. And in fact, we don't even have to because we have a stipulated order for abatement. So I fear that we're going down a path that is not even relevant, but I'll allow a few more questions if you really need to finish this line up,
The
but
point-
it's
I
not
mean,
relevant.
Everybody, as a member of the board, will make a finding and a determination and a vote. You have to be satisfied that all the information provided and all the questions you raise are in fact answered before you vote.
As long as they're relevant to the findings that need to be
well,
made.
Where if there's notice of violation that has no significance or meaning, why is it before us today? Why do I have to take a look at it?
We're just not appealing, there's no appeal as to whether it is proper, meaning it has everything you'd like in it. There's no appeal process for that.
My concern was responding properly notice, and the properly notification therefore should include all the data, all the information to be listed on the notice violation. So that if you're going to include all the dates, when you make the,
Okay, I think you've asked the question, why didn't he include it? That was answered. You asked the question, all the relevant questions. If there's any other question about that has not been answered, this would be the time to ask it. But please, only a question.
that was the reason why I thought we should continue the hearing until the other person was here.
Okay, well, I disagree.
You know the answer.
I did have a follow-up for Mr. Hemant, Desai.
I'm sorry?
Well, question.
You have a question for Mr. Should we, well, let's return to Mr. Desai.
Mr. Desai, you cited the fee, what was it, 2,480, is it?
$2,480.93.
Now, is that the fee they have to pay before they can submit a new application?
Yes.
Because by paying the fee, the permits don't get reinstated. Did you check with finance what they actually have to pay before they can submit a new application?
I believe this was the amount that I looked up on their finance outstanding balance.
Right, but, okay, I think you may want to double check, but because what would they have to pay to submit a new application? Because by paying this, their old permits are not being reinstated.
No.
No, and, and whether there's a hold in accepting new application unless they pay this amount, my understanding, and I could be wrong, it's been the survey, is that, it's looked as a new, and maybe the only thing they might owe is a hotspots fee or something, and not the annual operating fees.
I believe you're right. I was hoping to tell Ms. Esposito was hoping to see her, and I was going to tell her to pay this amount before, the new applications are to be submitted.
Okay.
So she needs more.
Right, or to check with billing services what they
Right.
have to clear before they can
Correct.
submit a new application.
Right.
Okay.
Are there any other questions for Mr. Desai or Mr. Leong, since we went back to Mr. Leong? Okay. Senator, did you have a question?
One of the conditions that to be met is that they should apply for a permit, which means before they can apply for the permit, they have to pay the fee. And therefore, he's intending to tell her that. Not the fact that he's already told her, but she needs to know that's a requirement before she can
Is there
stipulate
a
to it.
question? Again, we can discuss this in deliberation.
I'm just as confused as the respondent.
I don't believe there's any evidence that the respondent is confused.
They were here.
Okay. Any other witnesses, Ms. Roberts? Okay, I'm going to ask at this time if there's any member of the public who wishes to be heard. I see none. Ms. Roberts, would you like to give a closing statement?
Thank you, Madam Chair. The evidence that we've heard from both Mr. Leong and Mr. Desai does show that the facility has violated District Rule 203 and is likely still in violation of District Rule 203 because the facility does have a paint spray booth and does not have a permit to operate that spray booth. The evidence that shows that violation was clearly documented by the inspector. The inspector physically observed the operation of that spray booth, later confirmed that with VOC records on future inspections, observed parts drying that the facility employees admitted was the result of the operation of the spray booth. It is not generally questioned that the facility has violated and is in violation of district rules. The evidence today suggests also that there is a path to compliance that is needed. The facility is not currently in compliance, and the stipulation that was put forth in Exhibit 1 laid out a path to compliance to get the facility to where it needs to be. As board members have suggested, the facility has not been totally forthcoming and responsive to all of the district's efforts. The district's efforts span 2 years now and have not been successful, necessitating this petition for an order for abatement for the board. But that stipulation that was reached by the district and the facility was a reasonable accommodation to get them into immediate compliance, to address concerns with potential burner that cannot be permitted or would have substantial difficulties being permitted, and the facility's indication that they may have wanted to use a different burner. It accommodated that by getting them a permit to operate the booth immediately, which is the district's primary concern because that is the violation that the district has evidence of. It also lays out a path to render permanently inoperable a burner that is the facility has admitted it has no plans to ever permit. And that stipulation was a reasonable accommodation that if it is not going to be permitted, it is reasonable to require that it be rendered permanently inoperable because it would otherwise be non-compliant if it were ever put into service. And it further required that the respondent will submit an application prior to the installation or use of any future burner to ensure full compliance with all district rules, principally District Rule 203. That stipulation was signed by the respondent and was submitted to the board. However, the district does request that if the board is unwilling to consider that signature as a stipulation, that there is sufficient evidence today that the board could issue this order, even absent a stipulation. The findings are met, that there is a violation. This order that is requested by the district does not act as a variance, and there is good cause based on the evidence that has been heard today. Thank you.
Thank you. First, before we move forward with deliberation and a decision, it was brought to my attention by the clerk that I did not formally make a motion, and so I'd like to do that at this time. I'm sorry? No, I didn't. Okay, but I could do that, and I think it might make more sense. So I'm going to formally make a motion that we. Sorry.
The proposed finding and decisions of the hearing board on this issue. At what point did it say stipulated?
Okay, we're going to get to that in a moment. I'm just making a motion with regard to our being able to rule on this in absence of the respondent. We all voted on this, but I did not make a formal motion. I'm going to do that right now. I move that in this matter, that we, under our Rule 8B2, rule on the petition in the respondent's absence, given that we have proof of service on the respondent. Was there a second? I never called for a second. Dr. Bernstein is going to second that. The vote, I'll just recall the vote. And this is just the vote to hear it, to hear this matter and to rule on this petition. It's not to hear it. We did hear it, but the rule is that we can rule on the petition in their absence. Ms. Verdugo-Peralta, how do you vote on that?
Aye.
Mr. Balakopalan, how do you vote?
Yes.
Okay, and Senator, you voted
I voted.
no. You had voted no. Do you still vote no on ruling?
Let's move it. Yeah, aye.
Okay, now you vote yes. Okay, and so Dr. Bernstein voted yes, and I vote yes. So now the motion passes 5-0. Okay, so we can rule in the absence of respondent. It does present, I think, a little bit of a wrench when there's a stipulated order and the respondent does not show. So I think we should look at this in both ways. So that way the board's decision, whatever that is fully fortified. So First of all, I want to just note that there was testimony that the owner, in fact, is Miss Lorena Esposito, or at least she has identified herself to Mr. Leong during his inspections as the owner. Mr. Leong has represented that he, in fact, has spoken with her on several, she has been present at all the inspections, and he dealt with her many times. She did in fact sign the order that is proposed as Exhibit 1 on page 4, and the question that the senator had asked is, how do we know it's stipulated? It does say, so stipulated.
It does say so?
Yes, please look on page 4 at the very bottom. It says,
Line 19.
so stipulated, line 19, it says so stipulated. Line 25 through 28 is the respondent, John Esposito Porsche, and Miss Lorena Esposito is identified as the owner. There's a signature, and it was not the testimony because she is an attorney, but it was the representation in her role as an officer of this hearing board and as a member of the bar, I assume, that in fact this Exhibit 1 was negotiated between Ms. Roberts and Ms. Esposito, and that in fact Ms. Esposito did send her signature over. So with that, I do believe we could continue, but we don't have the testimony of Ms. Esposito because she is not present. So let's just start first with a deliberation as to a stipulated order. In that, if we are all able to find that this is in fact a stipulated order, we don't need to find a violation. So all the questions as to the notice of violations, all that is just not relevant. What is relevant is that Ms. Esposito, by signing the stipulated order and negotiating it with Ms. Roberts, identified that in fact the respondent is willing to take the steps laid out in the order, that those steps are reasonable to bring the respondent into compliance. It has a nice tight time frame of submitting application by December 31st. That may or may not have already happened. We have no evidence as of this morning when it was checked that has in fact happened. However, that's a pretty tight time frame to make it happen. And then, of course, we have heard that burner, there's no, it is not, we know that it is non-compliant. We don't have to find that. Regardless, it's not being used. That is the testimony. There's no evidence anyway that it is being used. And so to have that disabled permanently by January 31st, 2020 is a pretty tight time frame. And so beginning simply with the question of whether there's good cause for a stipulated order. Anyone else have any thoughts on that? Senator? Anyone else? Mr. Balagopalan?
On the condition of the order, I think it's somewhat unclear because they're allowed to operate the gas burners associated with spray booth as long as it's a certified or compliant unit. So the assumption is right now it is not a compliant unit, based on photos that the engineer and the inspectors looked at. But they should be allowed to use it if they are operating a compliant unit.
Okay, but looking at this first as a stipulated order, they've agreed not to. So we don't need to find
I just wanted to then clarify
non-compliance.
that cease operation of a non-compliant, it should say the non-compliant gas burners, because the permit the permit is no longer valid, but potentially they can apply for a spray booth with a compliant burner and they can operate it,
Right, but what they're saying is, are you saying it's not clear that what is referred to in this condition is the existing burner that is
Right,
attached?
yes, and the assumption.
Respondent shall render permanently operated the burner attached to the paint spray booth. There is only one that is attached to the paint spray booth. Do you think that's
Well,
unclear?
I don't think it's attached. I think they haven't, I'm not sure if it's attached or I heard that they haven't hooked up the gas lines and stuff, so I'm not sure if it's physically attached or if it's down, it's there, And if they put in a compliant unit, then, and if they submit an application for the spray booth with a compliant unit, then they should be able to operate it.
Would you like to reopen to have testimony as to whether it is in fact attached? Because I would vote for that. We need 3 members to reopen. Anyone else? Ms. Verdugo-Peralta. So let's reopen if we can find out whether or not it is in fact attached.
Mr. Leong can testify to that. Mr. Leong, you have visited the facility and you've seen the paint spray booth with the burner, correct?
Correct.
And is it physically attached to the paint spray booth?
Yes, it is.
Do you know how it's attached? Can you explain that at all?
It's attached to the exterior wall, one of the exterior walls of the paint spray booth.
And is there any other burner at the facility that you're aware of?
There is not.
So the burner is the only burner at the facility,
Yes, it is.
and it's currently attached to the spray booth?
Yes, it is.
Thank you.
But the gas line is not connected to it, is that your understanding?
That's correct.
But it's a simple matter for them to hook up the gas line to the burner?
Yes, yes, it is. Yes, it is. The owner also related to me that there is no gas being supplied to the facility, so that would need to be put into place as well.
Oh, okay.
Any other questions before we close again? Do you have questions on this question that we reopened for with regard to the burner and whether this is clear?
I think when you look at condition number 2 and 4, it's not, and it's already been testified to, that the gentleman here, I'm sorry, I don't remember his name, said he would notify the respondent that they have to pay a fee before they can apply for a permit. And he had not yet notified the respondent that that's the case.
I believe the billing services send out notices for payments. So I was just going to tell Ms. Esposito that when I see her, that you have to do this.
She signed the stipulated order, which requires 1 and 2, 2 and 4 to be complied with. I mean, somewhere we've got to break down the communication.
Is it normally the role of the engineer to tell a facility how much they have to pay in order to apply for a permit and receive it?
No.
Okay. And to your knowledge, were the proper channels of communication as to the amount that is due not followed in this matter?
I believe they know what needs to be done. I mean, Jason already referred them to our billing services, and all they had to pick up the phone, call them, and ask them how much do they owe, and write a check.
Okay, thank you. I'm going to close again, because, right, I think
Signed the
we're...
order, so.
Okay, thank you. We're reclosing. Thank you very much for that additional testimony, and we're going to reclose the record. And so the first question, I think, is assuming that we rely on the stipulation and the signature here, even though we don't have Ms. Esposito to say, yes, in fact, that is my signature, that we have good cause for this order. And is there anyone else who wishes to say anything on that? Okay. With that, I then want to also just, for clarity in our record and to make sure that our ultimate decision stands, I want to, okay, did you have?
I want to be satisfied that the district is satisfied that the respondent understand condition 2 and 4.
We closed the record.
understand,
We
okay.
did ask that question, and I think we received significant amount of testimony from Mr. Leong that in fact he had conversations with Esposito, that he did direct Ms. Esposito to, I wrote it down, to, he gave her phone numbers, he showed her how to access on the district's website what she needed to know about payment and filing or applying for a permit, and that she in fact understood. So I think that's clear. And of course, I will go back to the fact that this was a noticed hearing, and the respondent received personal service was checked off. Personal service on the owner, Ms. Esposito. And Ms. Esposito, for whatever reason, has not shown today, and so I don't believe it should be to the benefit of a respondent who does not show up at a hearing that we either continue it or we don't make decisions based on the fact that they're not here to give a different side than what we're hearing. So I wanted to
May I have one question, Mr.
Yes. Well, no, question,
For clarification, you can explain it to me.
we're talking about deliberation, yes.
Yeah, like John Esposito is the Porsche. Is it the name of the company or name of the person who owns the business?
I think that's the name of the business. The name of the business is John Esposito Porsche, and the owner is Miss Lorena Esposito.
Make sure.
I wanted to also, just for clarity of the record, I believe we could also make the findings that are necessary for a contested order for abatement. First of all, most importantly, that there is a violation, and let's discuss that. Regardless of whether, it's our feeling that notices of violation should be clearer or should list multiple violations and every date on which there's a finding of violation. I think all we need to find today is that, in fact, the last time they were inspected, which is on August 19th, I believe, 2019, there was evidence both in discussing with, I forget his full name, Gus, I forget his last name, the painter on premises, and in observing that there were wet and drying paint parts right outside the paint spray booth, that the paint spray booth is still in operation. So an NOV was issued. And there is testimony that as of today, there is no record that any permit for that paint spray booth has been applied for. But no application has been submitted according to the records and the most up-to-date information that was given to us today, and we have received no conflicting information from the respondent. And so based on that alone, without even questioning the rest, I think we can make a finding of violation. I don't know if anyone else wants to discuss that. I'll open for discussion. Ms. Verdugo-Peralta.
I agree with the fact that the inspector has given the respondent all of the vital information to be able to come into compliance, pay the fees, and go forward. And it's obvious that they're ignoring all of that. He took the time to speak to the painter, Gus Flores, as well as Miss Esposito. So you have two people there who could have either called up the district to find out the information, but they don't seem interested in doing that, let alone not appearing today. So I also find good cause. Thank you.
Thank you. Mr. Balagopalan, did you want to add, and in particular on the violation issue?
No, I think if the inspector had provided information, I think when in 2017, when they were there and the permit had expired, the inspector had explained to them they can reinstate the permit by paying the fee plus the reinstatement fee, and that would have reinstated their permit, and they had opportunity to do that. And if they had difficulty in paying that, they could have appealed to the fee review committee and got payment plans for the, but apparently they didn't pay the annual operating fees, so that's why the permit expired. And they had a year, actually, according to the rule, to reinstate it by paying the reinstatement fee, but they didn't avail of that opportunity, so they continued to operate without the permit.
Thank you for that. I agree. And that would lead into our next finding, which we need to make, which is that in order for abatement would not constitute a taking of property without the due process of law. Well, starting from today, that we concluded and ruled that we can rule today because there was notice of today's hearing. It was the respondent's choice. It is, I just want to note for the record, it is now almost 11 o'clock a.m. and the respondent still has not shown, even though we waited 15 minutes at the beginning of this hearing before we started. Also, as Mr. Balagopalan, you just mentioned, there have been many inspections, a notice to comply, 2 notices of violation, all with regard to the same continuing violation. We heard testimony of many conversations dating back to 2017, which should have brought them into compliance as of today. So I think the due process of law has been followed in this matter. And finally, if the order for abatement results in the closing or elimination of an otherwise lawful business, it does not. Well, we did not hear whether or not the paint spray booth is the only thing that they do at this facility. However, even if it is, the only finding we need to make that such closing would not be without a corresponding benefit in reducing air contaminants. And I think it's clear that permits and the use of correct burners and other equipment are very important for regulating how much emissions and making sure that those emissions are the lowest possible from whatever equipment is at the premises. So I believe we can make that finding regardless, but anyone else wish to add to that or anything other than
No,
Mr. Balagopalan?
I think we can make a finding. The only, to make whole, they'll have to submit an application for operating without a permit. And I think they, as Mr. Hemang Desai said, if they're listening, they should call the billing services to find out exactly how much back fees they have to pay before they can submit the application. They may not have to pay all the 2,480, but they can check with billing services and find out how much they have to pay before they can submit the application. Because if there's some hole, the district will not accept the application until they pay the back fees and then the new application. So that's something they should do and contact billing services. And they've been told to do that, but so far it doesn't appear they have.
Any other thoughts? Well, otherwise, I'll make a motion. Senator?
I agree they're in violation. They were aware of it because they received proper notice. You know, sometimes people fail to comply if you don't put the hammer on them. And when you wait a year after the investigation to serve them, and it's not detailed as it on paper as it should be explained, they don't take it very serious. That's my opinion. Notwithstanding that, they're in violation, and whatever action to be taken, we should find them to be in violation. I think even though we didn't follow through in detail to explain what they did wrong in the period of time they were doing it wrong, I think that was, in my view, that's a little negligence. We honor them all the time. They might have been more responsive. But nevertheless, they're in violation, and we should hold them as such.
Dr. Bernstein?
Thank you, Madam Chair. Appreciate all the comments from my colleagues. It seems obvious in going through the list by the chair that we do have the findings to grant an order for abatement. But it also seems to me that I need to comment on the fact that this company has been in violation in one way or another since March of 2016, I believe.
2017.
So they said March of 2017. and repeatedly were notified of such and decided, made a conscious decision as far as I'm concerned, and knew exactly what they were doing to avoid coming into compliance. And so I think they're getting off lucky today in granting them the order of abatement, because there seems to be no reason whatsoever that they should not have come into compliance at the very first turn. And so I thank everybody for the deliberation, and happy holidays, Esposito Porsche.
Thank you for that. If there's no other thoughts, which I appreciate, I also appreciate all the thoughts of my fellow board members, I'm going to make a motion. And that motion is in the matter of South Coast Air Quality Management District versus John Esposito Porsche, case number 6164-1. I move that we grant the order for abatement in exhibit number 1, and I will make some changes.
Stipulated order.
It is a stipulated order. However, I'm going to make some changes, and I believe that so part of my order will be that we have been able to make a finding of violation, which will end all the other findings that are necessary. So we can make some changes. The changes will not be to the order itself. The changes will simply be to reflect what occurred today. And since we don't have stipulation, I don't know why we wouldn't get it, but we don't have it. So I'm going to call it a stipulated order, but it's also going to be based on the findings for a non-stipulated contested order. I further move that we make the following changes. So on page 1, line 27, where it says we're going to delete was represented by Lorena Esposito, owner, and instead we're going to say did not appear. And then we're going to insert a sentence. I'm sorry? Did not appear, that's correct, period. And then
Where was that, Madam Chair? I'm sorry.
that is on the first page of Exhibit 1, line 27 at the very end. And then I'm going to insert a sentence after that, which is, the board was provided with a proof of service of the petition on respondent. Yes, of the petition on respondent. And the board voted to proceed in accordance with Hearing Board Rule 8B2, period. Also, on page 3, the very right around line 4, right before the conclusions, I'd like to add a paragraph 10, and that paragraph 10 of that factual paragraph 10 will be the district submitted testimonial evidence that the burner currently attached to the spray booth does not match the description to the spray booth, does not match the description in respondents, and is it the original permit application? Is that, yeah, in respondents' original permit application. And finally, on line 23 of that same page, page 3, number 3, I would just, to address Mr. Balagopalan's concern, after the word burner and before attached, I would insert the word currently attached. And that completes my motion. Is there a second? Dr. Bernstein seconds the motion. Is there any discussion on the motion? Ms. Verdugo-Peralta, how do you vote?
Aye.
Mr. Balagopalan, how do you vote?
Yes.
Senator, how do you vote? Dr. Bernstein, you vote yes. I vote yes. Motion passes 5-0. Okay, thank you, and good luck, and we hope to see compliance. We do have training, but we're going to be adjourning the hearing now unless there's other business, board members. We're going to adjourn the hearing, and we're going to go to, I believe, CC 2 or 8?
It's 8, I think, isn't it?
CC 8? Okay, and where we will hold our training and other things. Okay, we're adjourned.